Committee Room 30. Sound.
Okay. So the meeting is now in public session, and just remind members that it's being broadcast online and throughout Parliament buildings. If you can make sure that your mobile phones are muted and no photography or recording is allowed. Okay, so going to proceed with the agenda. So we have potential apologies from Claire, who may be joining online, and we're not sure whether Emma's going to be able to join us.
Trying to get on now.
Okay, so Emma's trying to get online, so we'll welcome her when she joins. Any declarations of interest to declare? No? Okay, so just one small piece of chairperson's business. So just this morning, as chair of this committee, I attended an event in Belfast City Hall, investing in good relations and collaborative education. Junior Minister O'Reilly was there. It was a really good event. Called Body Up, and it's funded partly by TBUC and Urban Villages. So I'm going to, after today, I'm going to send a wee note of congratulations, because it seems like a really positive programme, and it's good to see how this money is being spent in the community. Okay, members, so in terms of draft minutes, then you'll find them in your pack. Any members have any issues to raise with them, or are they content that they're Okay, thank you. I'll go ahead and sign them then. Matters arising then. So, following last week's session regarding the recent racist incidents, the PSNI has asked to attend this committee in order to give their views on what was raised and the incidents over the summer. So the clerk and I have been working on and have identified a potential slot of the 2nd of October. If members are okay for me to include that. It may not be as long a session as we had wanted, because that's the day that the First and Deputy First Minister are coming, and also the TO officials are coming to give us an update on the recall motion asks, but I think it's better to get, well, it's still a live conversation, to get them here. Okay, so we are also, sorry?
We'll probably come to it in our forward programme, but see the week after that,
yes.
We have 3 sessions in. I think we've one with the Human Rights Commission as well.
Sorry, let me just...
But what I was going to suggest is if we could just do a separate session with the Human Rights Commission, particularly given...
Oh yes, there's quite a lot there, isn't there?
There is. It's just the Court of Appeal judgment on the ICRIR stuff.
Yes.
Mm-hmm. If we could just do that separately.
That's a good idea. Okay, we'll work that. We'll work at that. Thank you. Okay, anything else before we move on?
Chair, could I make a couple of points relevant to what we're discussing today? It's primarily correspondence, 78 to 82 pages at the back of our packs.
We'll get to correspondence.
But at the same time, it's very, very relevant. It was to do with witnesses that were meant to be here today. I just wanted to pick up a couple of points. And LaSalle said that the chair wrote to them on the 2nd of July, and they only replied last week. Serious concerns regarding the correspondence they've sent to this committee. One of the things is they claim that the Executive Office have failed to tell them what their contribution to the redress scheme should be. They talk about 3.5 million they've quoted in their correspondence cost to date, but they haven't provided any breakdown of that. I would like to know how much of that was their own legal costs and how much of that was paid to the Redress Board. And the other one on page 80, Sisters of Nazareth. Couple of points to pick up here. Just quoting: the content of the written submission is provided for the private use of the committee, and permission is not given for it to be used publicly or for any other purpose. And they go on to say the sisters were used to provide care on the cheap, and advantage was taken of their generosity from charitable donations from support of local business and communities. What remit has anybody that's been asked to come to this committee to say that their information or correspondence should be treated in private? And it's almost as if they feel that we should owe them. Well, so, moving on, Chair, just to labour the point if possible, they've been asked to come to this committee. Have we reminded them of the Section 44 where they have a duty that we can compel them to come? My advice would be that we look at reminding them of that statutory instrument we have, and if they don't come, they have serious questions to ask on all this, and I would like to ensure that this committee takes all appropriate measures to bring them here.
Okay, thank you for raising it at this stage. As you know, this is your 3rd week. We have been dealing with this from the very start. The Historical Institution abuse has probably been the most high-profile issue that we have been dealing with. We had tried to get them here, I think it was June, first of all, some of the institutions, and we have been playing this cat and mouse game ever since. The clerk has looked at the compelling element of it. If you'd like to give an update then, where we're at with that.
Sure, so it's quite a lengthy process, but we're at the beginning of that process, so members are quite clear that they want to ensure that the institutions attend. So the first stage of that is to look thoroughly and collate all our communications we've had with each of the institutions and the responses that they've given. And the next stage, and during that, they have been reminded of the Section 44 power. Then the committee takes legal advice from legal services of the Assembly to look at to ensure that if we proceed down that line, or the committee proceeds down that line, that it's a safe route to take legally. So they look at all the ins and outs of what's happened so far, and the reasons for wanting them to the committee, and those are the legal sort of frameworks.
I'm going to make two small points, then I'm going to invite the panel in. Okay. First of all, we had asked Paul Sweeney, who was the facilitator, to come today, but he's unable because he's on holiday, to talk to us about how the payments were calculated, and also there was another point we were going to talk about.
Yes, so it's about the negotiation process.
Yes. So it's on our agenda now.
Will there be an update coming back to committee? I know this is only my third week, as you have
Yes.
pointed out, but certainly from the correspondence, they've been held liable by the inquiry. They've basically admitted so in here, and we should be taking all measures to make sure they come and provide answers.
We're not letting this one go. Okay, we're going to move on. So our first briefing today is on the Historical Institutional Abuse Redress Board, and you'll find the clerk's briefing page 15 if you'd like to come forward, and page 17 you'll find the briefing paper from the Redress Board themselves. So I am going to welcome to the committee the Honourable Mr Justice Fowler, who is the President of the HIA Redress Board, Jim Coffey, who's the Secretary, and I'm sorry I don't have your name.
It's okay, it's Gillian McLaren, I'm the Deputy Secretary.
Okay, thank you very much. Well, you're all very welcome, and thank you so much. I know you're very, very busy people, and it took us a bit of time to get a slot, but we are delighted to have you here. We have taken evidence from victims and survivors of people who've been through the process, so we are quite familiar with a lot of the issues. We appreciate your... Is there...
So sorry.
That's okay. Thank you for your paper. It was really digestible and really helpful. So if you'd like to make some opening remarks, bearing in mind we have read your briefing paper, and then we'll get to questions. Thank you.
Yes, thank you very much. Thank you for the opportunity to engage with the committee today on the operations of the Redress Board. I'd first like to take the opportunity to pay tribute to the many victims and survivors of historical institutional abuse in Northern Ireland, both as individuals and as members of victim and survivor groups, for their resolve and their fortitude over very many years. As you'll be aware, I was unable to accept your initial invitation to attend the committee in May of this year, but did provide you with a written update, let's put it that way, of the performance of the Redress Board. I hope it was helpful to the committee. I intend to keep my opening remarks fairly brief, so that will allow for questions. But we'll start by introducing my colleagues who you've perhaps been introduced to. Mr Jim Coffey, who's the Secretary, and Gillian McLaren, who is the Deputy Secretary to the Board. At the outset, it's important to state that in accordance with convention, I cannot discuss any policy or decisions that have been made, nor can I discuss individual cases. You will be well aware and no doubt understand that I simply cannot do that. However, I want to work as constructively with the committee as possible in an open and engaged way as best I can with those convention strictures. The Redress Board's statutory responsibilities and functions within the wider redress scheme are limited to the receipt and processing of applications, the determining of applications, and the issuing of instructions for payment of compensation to victims and survivors. That's clearly set out in the 2019 Act, which I'm sure you are all aware of with your deep knowledge of this. As President, I have the sole statutory responsibility for the effective and efficient discharge of the functions of the Redress Board in accordance with the legislative framework which governs the operation of the Board, and by which it is bound, and I must apply the legislation and the statutory framework that has been put in place. The Redress Board is operationally independent of government and other agencies. By way of important context, I should say that as part of the financial aspect of the redress scheme, there are a number of distinct roles and responsibilities. The Commissioner has a statutory responsibility to provide advice and information to applicants about making an application, to assist them in obtaining institutional records. The Victims and Survivors Service, VSS, performs an extra statutory role to provide emotional and trauma-informed support services generally, to assist applicants in particular, to assist applicants capture their lived experiences. And finally, solicitors have a statutory role, and that's to assist applicants in a trauma-informed way to prepare and submit statutory compliant applications to the Redress Board for their determination. Redress Board panels consider applications in relation to a wide range of institutions, from orphanages, workhouses, state and voluntary residential childcare homes, juvenile justice institutions, industrial schools, some hospital settings, and prisons. There is an infinite variety between applicants' experiences within these very different institutions, and there's often a very considerable difference between the periods that individual applicants have spent in institutions. That could be anything from a few days or weeks in relation to, for example, juveniles on remand, to almost the whole of a child's childhood, for example, in a childcare home. The experiences that applicants have encountered vary from exposure to a harsh environment to the most grave and pernicious incidents of physical and sexual abuse, and panels consider these applications through a trauma-informed lens. Under the Act, the Redress Board is restricted to making awards of compensation between £10,000 and £80,000, and that's based on the severity of abuse detailed in the applicant's unique statement of experience and any other additional evidence that the applicant may care to submit in support of their application. For clarity, I must advise that individuals are not compensated under the Act for solely being resident in an institution. There is no common experience payment in this scheme, and that is by statute. It is the role of independent three-person panels to decide if an award of compensation should be made or not, and the amount of any compensation to be awarded based on the severity of the matters detailed in the applicant's statement of experience, and also any supporting evidence that they should care to submit to the panel via their solicitors. Prior to the opening of this financial redress scheme, the Redress Board developed in consultation with the then interim advocate and victim survivors groups an evaluative framework to determine the value of wards within the financial range available to it. And there was banding guidance drawn up and made available at the very outset of the scheme. It's available also on the website, and applicants, solicitors, interested stakeholders are directed to it to inform their approach to making an application to the board. Committee members will wish to note that 99% of applicants are represented by solicitors who have a vital role in assisting applicants to thoroughly prepare their applications, but also a role in advising them of their rights to pursue alternative compensation remedies, which may include recourse to the High Court, the County Court, or Criminal Injuries Compensation Scheme. The financial redress scheme operated by the Redress Board offers applicants timely, paper-based and less adversarial choice rather than those other remedies which may attract higher levels of compensation, but by their very nature are adversarial, take much longer to complete, and are much more likely to involve oral testimony and cross-examination, which I'm sure you would realise would ultimately increase the potential for re-traumatisation of already vulnerable victims and survivors. As of the 31st of August 2024, the Redress Board has received just over 4,600 compliant applications, and has considered 4,500 approximately of those applications. They've made determinations totaling 93 and just above £93.5 million. Currently, at present, only 57 applications and one appeal remains to be considered. The Redress Board has an aspiration to have an application considered by a panel within 20 weeks of receipt to facilitate statutory verification and validation process. Currently, applications being considered by a panel are considered within 7 to 7.5 weeks of receipt. This compares very favourably against other redress schemes within Ireland and the UK. Some of those schemes incur timescales of between 12 months and 22 months. I'm aware that this committee in 2021 previously took testimony from others that it would take somewhere in the region of 10 years for the Redress Board to consider such applications. This is clearly not the position. The Redress Board will cease to receive applications for compensation on the 2nd of April 2025. The committee will be aware that the Commissioner has a statutory responsibility to publicise the role of the Redress Board. We are aware that the Executive Office and the Commissioner have been leading an ongoing public awareness campaign during the past 18 months to promote the redress scheme in its full context, which includes a wide range of emotional and practical support services to victims and survivors by other agencies. In addition to the financial aspect of the wider redress scheme operated by the Redress Board. Committee members will observe from our submission that the number of applicants and the applications received in each of the last 4 years has reduced year on year, and as yet there has been no discernible increase in applications since the outreach work has been conducted. I'm now in danger of straying beyond my commitment to be short, and I'll now take questions.
Thank you very much, and thanks again for your written submission. Okay, I'm just going to pick up on that issue of the closing date for the applications being the 2nd of April next year, and the publicity campaign, and you said that there was no discernible increase in applications for compensation received. Given your experience of leading the board, what do you think that they could be doing now in this last 6 months or so to try and just get a last heave in terms of getting people to come forward?
I understand that there are some further steps being taken,
Okay.
but there has been a fairly concerted, I'm sure perhaps even maybe members of the panel have received through their door or would see in public spaces the flyers that were sent out, and certainly as far as we're concerned that there has been fairly considerable outreach work. There's also some outreach work being considered in locations outside of Northern Ireland, also in centres where people would have emigrated to.
The question was, so we've met with the Commissioner and she's outlined what
indicated.
So I'm asking you, is there anything that, given your experience of dealing with the applicants, is there anything that have you any observations of how it could be better promoted, or is there some gaps?
Somewhat outside of my remit,
Okay, I'll move on then.
in the sense that it's entirely a matter for the Commissioner, and we have engaged as much as we could to encourage that outreach.
Okay, so the issue there of the redress scheme, and quoting here a bit about a timely paper-based and less adversarial alternative to civil litigation remedies. So we as a committee, we will be engaging with the Executive Office and the mother and baby institutions around their own redress scheme. And again, given your experience, what advice will you be giving to the chairperson and the panel for the next redress? And is there anything that you would have done differently from the start if you had your time over?
That's a very, very different scheme with very, very different legislative provisions.
Yeah, but I'm just talking about in terms of...
It's very much, it's very different in many ways. We had the advantage of the Hart inquiry and report, which was very helpful in relation to our particular scheme. What is required is careful case management of applications. The Secretariat in the Redress Board have been proactive in encouraging applications to be complete when they're submitted, and while they have been reasonably flexible in waiting for some further information in terms of evidence to come in, there came a point in time it had to be a bit more strict on that, and perhaps a stricter time scale for that additional evidence to be lodged with the Redress Board would have helped. But that was taken care of by very proactive engagement with solicitors, indicating that it was required that applications to the Redress Board would be fully formed and would contain all evidence that was necessary for the case to go for a determination. That was made very clear at the very start of the Redress Board. It's something that should be reinforced at the start of any scheme. There's also an important point in the sense that progressing schemes for victims and survivors, expedition is important for them. That delay engenders and is likely to cause further re-traumatisation, and that's why we are pleased with the speed with which we are getting through these cases for victims and survivors.
Okay, just a quick one and then I'm going to pass over. So you've talked about that additional investigations regarding applicants' attendance, and you quoted a figure 8,161 requests under Rule 7 notices for information retrieval, and then you put a table in the papers around saying that you were awaiting information from 25. Does that mean that the vast majority of those requests for information were answered? And if you can even speak to how, because again we're conscious that a lot of these institutions don't always keep their records, and they weren't in a digital age and stuff. So I'm just wondering around that whole issue of information retrieval.
In terms of information retrieval at that stage, that's for validation and verification purposes. And yes, the vast majority are replied to. My understanding is that they are chased up reasonably proactively.
Yep, I think of the 8,700 odd requests, there was about 3,000 which verification couldn't be provided.
Okay.
And on that basis, the Redress Board took additional investigatory steps to verify the attendance on behalf of an applicant. So that was the scale of records that weren't available to
Okay.
verify from the institution.
Right.
I think it's important to realise that we do not have a from cradle to grave record from institutions about the journey of victims and survivors through those institutions. We're looking at verification. When we can't get verification, we would go to other bodies that hopefully provide that. There's a series of bodies that we also go to. So it's not that we have every single detail. So it's not that. That's not the case. It's for verification purposes.
Okay, thank you. I'm going to move on. Deputy Chair, please.
Thank you. Thanks for coming in this afternoon. I wanted to ask around applications that you haven't determined to get an award, and I think I see there it's around 12% that apply are not given an award. Can you maybe ask if there's any sort of trends in relation to that? Is there any trends you see about why people aren't getting awards?
Not in relation to trends per se, but the corollary of that is 88% do receive rewards. And dealing specifically with those who do not get awards, there are many reasons and varied reasons why that happens. Perhaps one of the most common reasons is the lack of detail and specificity contained within the statement of experience. It's made very, very clear right from the outset in the guidance documentation provided by the board that what is required is as much detail as possible to be given in relation to the abuse that has occurred. Unfortunately, sometimes the statements of experience are bereft of that degree of detail and specificity, and it's a statutory obligation, it's a legal obligation that the board, because it's not a common experience payment, the board must assess and determine whether on the balance of probabilities it has been established that the applicant has indeed suffered abuse. And it's a question of proof, reaching that threshold of proof on the balance of probabilities, and quite often that there's just insufficient detail contained within the statement of experience. Sometimes they come in and they may only be a few lines, and it's nigh on impossible to glean any specific detail about what has happened or who has said carried out the abuse or any particulars of who may have witnessed it. All of that has been signposted to solicitors and applicants right from the start, and that approach has been the same and has been reinforced by the single judicial member on appeals, that is a correct approach, and indeed in judicial review proceedings.
Thank you. I think from my own perspective, I would like to see the scheme be as inclusive as possible. In regards to posthumous applications, do you think in hindsight the criteria for posthumous applications that it can only be made by a spouse, a partner, or a surviving child, do you think that was the correct criteria and people to determine? Because I have dealt with constituents I've been in touch with who've lost brothers and sisters and siblings, and even a parent who's lost a child who would have been eligible for the scheme, but because they're not a spouse or a partner, they can't apply posthumously. And they also made the point to me that some of the abuse that these people received was so horrendous that it actually inhibited their ability to form relationships, to have a spouse, to have a partner in their life, and to have children. So I think a lot of families who wanted to make posthumous applications have felt very hurt and let down by that, and think in hindsight that is something that maybe shouldn't have been proceeded with.
Well, that in a sense isn't for me to determine. That's a matter. These matters were discussed in advance of the legislation. The parties, in fact, met and debated these issues, and indeed there were amendments made as a result of those discussions. And in essence, that is a matter should have been dealt with in advance of the legislation.
Okay, thank you. Brian, please.
Okay, thank you for your attendance today and for the detailed report before us. You've set out that you have, in a timely manner, processed many applications and are down to just a small number. In terms of the Hart report, setting out the overall redress scheme, that it will include also personal support for people, is that beyond your remit? Is that just under the commissioner?
That was onto the commissioner.
Yours is the financial
delegated
compensation
to VSS. That's outside of my remit.
Yeah. And in terms of the money that's been paid out, again, you might say this is beyond your remit, £93.5 million. How much of that has actually been retrieved in payments from the institutions where the abuse occurred? Or is the government paying this out in advance?
The government is paying that out in advance. We do not take any part in recovering monies from any of the institutions. This is a scheme that the Redress Board does not engage with institutions other than verification purposes.
Mm-hmm. Okay, I was aware that you might say that. You wouldn't be able to give a rough figure on how much has actually been paid to date from the institutions compared to that figure that has been paid out?
I wouldn't.
Yeah.
Sorry to interject. So that's why we're wanting Paul Sweeney here. So he's going to talk to us how he's calculating it and how much has come in to date, but it's on the agenda.
I presume that's the reason. You were discussing the matters earlier.
Yeah. And finally, in terms of, I appreciate this is sensitive and difficult and times harrowing work, but I would hope that you're going stretching yourselves as far as you can to ensure that everyone who's entitled should receive compensation. And we touched on it earlier about the lack of records in some of the homes. Can you clarify if a written record of residency does not exist? What other methods have you employed to demonstrate that someone was resident?
Looking for health records. We look at PSNI records. We will engage with the Northern Ireland Courts and Tribunals Service to, particularly if there's any, if it's a juvenile detention centre or something like that. We also engage. Sorry, just bear with me. With a number of other bodies, the Department of Education, and also importantly, I almost missed, was PRONI, the Public Records Office in Northern Ireland. So we look at all of those. We also encourage, and we have in our guidance, that when a statement of experience is being filled out, that someone who was in the institution with the applicant could be brought to give evidence of what they saw either happening to them or even corroborative evidence that they were actually in the institution. So there's a number of ways. That's why there's the 8,000 plus applications and further follow-ups of 3,500. So we do try our best to verify and try our very best to signpost people where they can get this information, and then take an enormous amount of steps ourselves to try and assist.
Okay, thank you. Thank you, Chair.
Timothy, please.
Very much, Chair. I suppose I probably can guess the answer to your first, and it's taken back to the correspondence we were discussing at the beginning. So I'm guessing I don't want to put words in your mouth, but you aren't in a place to confirm if the Sisters of Lazarus have contributed towards the redress system at all?
That is not within my remit.
And the SAL have provided a figure to us of 3.5 million, and I'm guessing that once again you
It's
would
not
be in a
within my
position.
remit.
Well, that's all right. Moving on to paragraph 17-18, you spell out the important role of the Victim Support Service to deliver a range of emotional and therapeutic support. So going back to the very beginning of the VSS, it was set up for victims of the terrorist campaign. Was there any additional money provided by the Executive Office when the work of the Historical Institution Abuse Redress Board was added on to that workload?
We wouldn't be privy to the funding arrangements for VSS. That would be a matter between the Executive Office and VSS. So we have no insight into
Mr. President, I'm not aware.
Moving on, paragraph 85 of the Hart report, it talks about, so you have the homes that have been, the inquiry has been into them, and it lists that those who are coming from a home outside of the inquiry, they're encouraged to have legal representation. In your evidence, you have provided that 99% of applicants have come through solicitors. Can you give us any sort of idea how many of them people have come from homes involved in the inquiry, and how many have came from outside of homes involved in the inquiry?
I don't have those figures to hand, that break up.
No, I don't think we could divide it at that level, but there's solicitors represent the majority, the vast majority of applicants, and a lot of the applications come from those institutions, the 22 institutions that were investigated by Hart.
I would be keen to know how many came from outside those 22, to give us an idea of, are people being missed purely because, you know, the abuse didn't take part in, say, a church setting? Is there a need for inquiry into clerical abuse?
Again, that's outside my remit. I'm dealing with this issue.
I think what we can say is that we have received applications from applicants who have attended 135 different institutions, and Hart investigated 22. So there are lots of institutions that Hart didn't investigate that people have attended and have made applications to.
Can I just interject quickly? We got some information back as a committee around solicitors' fees, how many cases and stuff. I'm going to ask the clerk if he can supply that to you. That might give you an indication of where you're going. And secondly, just committee, the clerk, the deputy chair, and I met with the chair, Lisa Caldwell, who is the chair of the interdepartmental working group into institutions, etc. She's going to come before committee to talk to us about historical clerical abuse soon. So this is something that we will be coming back to.
Well, could we get the figures for how many cases have come from 22 institutions and how many came from outside of that, if possible? Moving on, so we've heard that there's 93.5 million has been paid, 57 applications still outstanding and 1 on appeal. Are you in a position to break that down? So if the money's paid, how much of that was paid to the Catholic Church institutions? How much of that was paid to people coming forward from state institutions? How much of that was paid to people that have come forward from charity? You've mentioned Bernardo's. Was there any other charities that have been involved?
No, we're not in a position to break that down, because within each, it's a global award, and within an application there may be more than one institution which is involved. So that's not an exercise that we have, nor were we asked at the start to do. So that's not an exercise that we have done.
So you've said the money it's coming from government, but at some stage government will be looking to recoup some of this money. So would it not be necessary to understand and know? So if you're making a payout to people that have come forward from the Catholic Church, you will then know how much you're going to the Catholic Church to ask them to contribute. Same for the state, same for charity. Would that not be part of your work?
I think that's a matter for Mr. Sweeney, who's doing that work on behalf of the Executive Office, as I understand, and we have provided some raw data, but it's very much a calculation that the Executive Office are involved in, and the board can't really engage in that. We're outside of that purview.
Bernardo's has been mentioned. Can you tell us, is there any other charities that would be involved?
There's a list of the institutions for which applications have been made to the board on our website. So there's a full list of all of the institutions that have been subject to an application to the Redress Board.
Final point then to say is, obviously I commend the speed that you have been able to work through this. You had said that it would take 10 years. You've done it quite comfortably. Inside that, one of the issues, and this is maybe going off topic, there's quite a number of people that have come to my office regarding victims' pensions. What you have been able to do seems to be a process in place that has worked. Has there been any other like victims' pensions? Have they approached you to get some good practice of how they could do their work better? And if they haven't, is that something you would be open to share that knowledge and what you've been able to do?
Each scheme is different. So what works for one scheme may not necessarily work for another, but certainly the principles that we have adopted we will share with the schemes.
You'd be open to that. Thank you.
Okay, thank you. Harry, please.
Thank you very much, Chair. Thank you, Justice. Can first of all say I was appreciative on your introduction where you first of all you mentioned the victims and survivors. That's very much appreciated. Can I just go on, maybe we follow up on the question you asked, Chair, when you were talking about the end date 2nd April 2025. When I was reading through the papers, I was thinking, is this a guillotine cut-off? But you went on to mention there would be a contingency plan. I was just wondering, could you maybe elaborate a wee bit more on the contingency?
Well, when we modelled on not the modelling is intended to model how long it will take us to conclude cases after the cut-off date. And we've modelled it on if we receive a spike in applications of, say, 10%, we've modelled on how long it would take us to deal with that. Or we've modelled it on if there was a spike in the last 6 months of 40%, how long it would take and how many panels we would have to engage to clear those cases. And the board has the ability to flex up and flex down. At the moment, because of the number of the applications we're receiving has reduced, we have reduced the number of panels.
Yes.
That's also reduced the cost. But if there is a spike in applications coming up to the end, we will be able to flex up and have more panels and deal with them. It's not a question of extending the time for receipt of applications, but it's how long it will take to deal with the applications that we receive coming up to the 2nd of April. That's the position. Hope that makes that clear.
And just a wee,
yes.
Please, Chair. On the hard recommendations, would you have followed all the recommendations there?
Again, I'm confined with the legislation. My role is to ensure the efficient and effective proceedings that take place within the board. It's not to speculate how I would have done it differently. That's my remit, is to deal with it within the four corners of the 2019 Act.
Okay, thank you, thank you, Jim. Thank you, Chair.
Okay, Sinead, please.
Okay, thank you, Chair. And thank you for your presentation and for your briefing document today. It was very informative. And can I just start off by thanking you getting through the applications in such at such pace and coming to the conclusions, because that's really important for these.
There was an incredible amount of work done by my predecessors in relation to setting up the scheme. The scheme required a lot of work to set it up. Mr. Justice Colton and then subsequent Mr. Justice Huddleston was dealing with the many applications that were coming in. So and the Secretariat were very, very motivated. All of the participants in this have been motivated, because you can't read the lived experiences, the statements of experience, without empathy. Mm-hmm. And the board wanted to progress these as quickly and as efficiently and with as little trauma as possible. And that's the way the scheme was designed. It's paper-based. Mm-hmm. It avoids confrontation, oral hearings, for a very good reason. Mm-hmm. But as I say, personally, and the panel members all have said that it is very worthwhile work.
I commend you and the panels for doing that, and I think to do it in such a trauma-informed way is so good, and this committee on a weekly basis are dealing with victims and survivors, and quite often their experiences of redress are not quite as clean as some of the figures here. Now, there's one area, I want you to talk through it with me, because just to have an understanding. Obviously, there was you have the right to withdraw an application, and 331 withdrawals have been made to date. Can you talk me through that as well? And are some of those that had to maybe withdraw? Is there any learnings that we can, garner from that? Maybe they should never have been involved in the process. They didn't fit into the legislative framework or remit for it. They may not even have been residents in the jurisdiction or whatever. So can you talk me through that, just so that I have a better understanding of it?
The most common reason for withdrawals is that the applicant didn't have the legal entitlement to make an application. For example, the reasons you've identified, they were over 18 years when they were in the institution. They didn't reside in a qualifying institution. They resided in an institution after 1995. And basically the most common reason is no statutory entitlement to actually bring that application. There's also applications that are withdrawn, and they're certainly substantially less, and those are incomplete applications, and that's where the solicitors are waiting for further evidence, further information to place before the panel, and it's taking a considerable length of time. And rather than wait with the risk of it going to a panel, they withdraw it, and then they put the application in when the evidence is available. And there's some times that perhaps even the applicant isn't prepared to necessarily wait either. It's stressing them, so it's better that it is withdrawn and then resubmitted. But that's a smaller number of them. There's also a smaller number would have been duplicate applications.
Right, okay.
So that's
what would be the reason for like maybe two different solicitors, or
that could be the case, or in from an individual themselves and then go to a solicitor, or just a mistake by the solicitor. It's as simple as that.
Is there?
Just bear with me one moment.
Is there a case of maybe too little evidence because the applicant themselves, a lot of these applicants may be in their twilight years, or that they can't provide the evidence, but their family know that they were in an institution, their family know that they were abused, but can't give that personal experience for an application. And I'd be concerned if that is a case for a number, maybe a significant number of those 331.
It's a very good point. That would be applications on behalf of someone who was in an institution, and that could be whether the person is deceased, or they're suffering from dementia. Or they're very elderly. And we have had a number of applications in respect of deceased persons. I think we've had 14 in relation to people who had cognitive or elderly issues. And what we have done in all of those cases, and as we are obliged by statute, is to apply the legislation purposefully. And we've signposted how they can bring evidence from family, siblings, etc. And we have dealt with, my understanding, 14
with dementia, and we've dealt with 140 roughly on behalf of deceased. So that's the number of applications. So we try to encourage people to provide other supporting evidence from siblings, family members, whatever. But most of the withdrawn ones are, as the judge said, people's memories fade and they don't realise they're in the institution at 18, not 17. And that's perfectly understandable given it's 40, 50 years ago. So the vast majority of withdrawn is simply that we've investigated the matter and been able to verify when they were there and at what age, and on that basis they accept that they fall outside the statutory provision of the scheme. So that's the withdrawn figure. The vast majority of them, as the President outlined.
We do understand that even giving a statement of experience has the potential to re-traumatise people, and it's better that they give it in their time. And we have been very conscious of that, and that's particularly so with people with dementia.
Yeah. I'm going to ask you a question. I don't know if it's a stupid question, but are you proud of the work that you're heading up and the panels?
I am, and I find it very rewarding.
Right.
I have worked with vulnerable people for many years. I don't want to say how long, but for a long time as a barrister and a judge, dealing with many vulnerable people in criminal cases and victims and survivors. And this is very rewarding work.
Okay. Thank you for it too.
Thank you. Carol, please.
Thank you for your presentation. So in your written briefing, you have issued 8,161 Rule 7 notices to institutions, and you've verified 3,459 separate investigatory searches. That's very, very time consuming. So, you know, in terms of the actual records and verification, I mean, has there been patterns from some institutions in terms of the lack of notes or record keeping, first of all?
Yes. I take that question. In respect to some of the prison establishments, some of the records are destroyed. So we have to then go to court records that are withheld within Prony, and through that there we can verify attendance through that route. Some of the institutions that set out in the Hart report have better record keeping at better times. So when they are not available, we will look to find out whether somebody attended a certain school. We'll be able to see if that school register is held in Prony, and then we'll know there's a gap in that person's appearance, which then we take as verifying that that person was at the institution because they were no longer attending school. We also have information sharing agreements with the Department of Health, who sometimes might have some other records about a placement in another institution, not necessarily one where the applicant's making a claim, but from that record we can demonstrate or be proved that that person was transferred to another institution. So again, that verifies. So those 3,000 additional investigatory steps is with the help of those other bodies. And they're very good at sharing information with us, and that's how we were able then to verify that the applicant was there, because the original institution doesn't hold the verifying record. So those bodies have been very helpful to us. As I say, the trusts and Prony have been extremely helpful in assisting us verify attendance where an institution hasn't got a record to verify the attendance.
So the prison service destroyed records, or, you know, notified people that the records are there to be picked up, otherwise they'd be destroyed?
I don't know about the prison's records policy at the time. It's just that they're not there now. So
no, I think they had to do that.
Yeah, they may have been their records disposal policy at that time, but that presented a certain challenge for us. But we have a mechanism of dealing with that challenge, and we've been able to verify the vast majority of attendances at remand centres or prisons.
So applications involving the child migration programme and also hospital settings. What are child migration?
It was individuals who were migrated as part of the child migrant programme in Northern Ireland to Australia. There was a roughly between 200 and 300, and the Hart inquiry had a module set out about that. And we have received some applications from individuals who are based in Australia through the Child Migrant Trust, who represent them, and all of those applications have been dealt with.
Every one of them?
Every one of them, yes.
Okay. In terms of hospital settings, you know, just could you elaborate on that?
One of the hospital institutions that was investigated on the Hart was Lissu. So sometimes people were placed there because there wasn't a suitable institution at that time for them, and they found themselves placed for residential care in somewhere like Lissu Hospital, and they're entitled to make an application to the Redress Board because it qualifies as an institution.
Is that the only example of where a hospital setting has been used?
No, there are a few, and they're on our list on the website. of those hospital settings. It's not for hospital treatment as such, it's where people were placed in these units because there was no suitable other child residential care facility willing to take the child at that time.
Which includes some mental health institutions.
It does. It does.
And the trauma that they received, and even the abuse that they received from other patients.
Sadly.
All of those things.
Yeah, all those things and more. So, again, I would just like to share Sinead's comments. I mean, this is, tremendous work. The volume of work that you went through, and I know it's people's lives, and I don't mean to demean it by calling it work, but certainly this would actually help, I imagine, in the process of even a plan and the trauma that would bring up. So the quickly it's expedited, the better it is. The cut-off date is the 2nd of April next year when you cease to accept applications, and you spoke about contingencies. Could you give me an example of what type of contingencies you're referring to?
I'd indicated that depending on the modelling, we have contingencies in place that we can flex. We can increase the number of panels, and we can increase the number of times they sit per week to get through the cases that we receive on or before the 2nd of April. Dependent on the number we get in, whether it's we just don't know, and we won't know, we will adjust the number of panels and the number of days those panels sit to accommodate whatever spike in applications that we get. In terms of the progress, we will be progressing them in the same way. We will bring the same rigour and hopefully expedition to those as we have brought to the rest of the applicants that we have received. And we won't be letting up at all in relation to the momentum and commitment. One thing that may happen if applications are put in on the last day of the cut-off day, what may happen is that some of the evidence or proofs will not have been garnered and ready to be deployed and given to the board. As we do at the moment, we will give a period of time for that to be done. Early on in the redress scheme, that took quite a while for those to come into as the additional evidence. But we changed that culture, and we got those in much quicker, and we will be applying the same. We will still give people time to get it in, but we will be saying, look, this has to be in, and it has to be in as quick as possible.
Thank you.
Thank you. Thanks very much for everything. I am conscious that we as a committee are obviously very interested in this subject matter, and as we approach April next year, I would appreciate if you even could write to us and just give us an update of where things are at, and if there's anything we can do as a committee in terms of supporting any contingency, we'd be happy to do that.
We can update you in a broadly similar fashion as we did previous to this meeting.
Thank you very much. So thank you.
Thank you.
Okay, members, take your ease for a minute. I have checked with the clerk. The clerk is able, Timothy, to get you all the previous committee packs. Conscious there will be a lot of information across a lot of areas there, so the clerk is happy at any time to sit down with you and sort of help digest that, so we'll get those through to you.
Could I just ask, Chair, when we are changing over evidence sessions, if we could revisit the earlier topic regarding section 44.
Yep.
Can you just explain in what terms has the committee written to these two, to LaSalle and Sisters of Nazareth? So I have it clear in my head of what exactly we have done, what we are doing, and what stage we need to get at if we haven't already expressly, used the terms section 44 to compel them to come.
Yeah, we've been collating the exact communications with each of the institutions and each of the replies, and all the replies have been different. So some haven't replied at all, or hadn't replied until recently. Others have replied straight away. Some had replied with some ambiguity, and from other jurisdictions as well. So we're collating the formats of our communications with them and them with us. And what their responses were, and that will all form part of any evidence for a Section 44 process.
And as you said earlier, we're getting legal advice as well then once
we'll
that's
get legal
completed.
advice. That's the next.
Are you saying we haven't reached that threshold yet to compel them under Section 44?
We had set a date for today, and we were bringing this panel in, and then we invited them all to come today. So it was only then whenever the lack of communication against that invitation and the refusal, etc. It was only then once this date had passed, then that allows us then to demonstrate that we had done everything up to this point, and we'll now move into this next section.
In the Sisters of Nazareth communication, they have said that it only got to the correct individuals on the 17th of September. Mm-hmm. Is that, you're talking about chicken and egg and cat and mouse, is that them delaying?
Mm-hmm.
Well, look, this is in hand, and I think that there's a bit of a play on words there, because I am very much assured that the clerk and the assistant clerk have been very tenacious in this regard. So once you have collated all of that in terms of dates and stuff, then we will share that with all the committee members of all the endeavours to date. Okay, everyone, so we're going to move on. So we're moving on to our committee inquiry into gaps in equality legislation, and today we're looking at older people. So I'm going to invite our panel members forward. So we have organisations, we had also invited organisations representing children and young people to attend, but it's a wee bit too short notice. So I really appreciate that these came forward. So do you just want to come and take your seats? But we will look at children and young people at a later stage. So members, page 40 of your papers, you'll find the clerk's brief. You'll also find the HNI's response to inquiry, and then you'll find the Commissioner for Older People's response as well. So I have got two names in front of me here. So we have Dr. Kelly Turtle, who's Head of Policy and Engagement at HNI. We've got Pascal McKeown, HNI. Then we've got Evelyn Hoy, Chief Executive, and
Conor Tinley from Tinley,
lovely.
from Commissioner for Older People.
You're all very, very welcome, and thank you for, again, such short notice, but we're really trying to move on with this committee inquiry. And if you just want to make some opening remarks, I'm not sure who's going to start.
We'll start then. Thank you very much, Chair, and thank you to the committee for having us to give evidence today. I'm just going to be presenting some opening remarks on behalf of HNI. We are the leading older people's charity in Northern Ireland. Our vision is for a world where we can thrive as we age, and our mission is to help people enjoy later life. We believe people should be supported to know and understand their rights, to remain as independent as possible, and to be connected to their communities. So that vision of a world where people can thrive as they age is one that we think can only ever be fully realised whenever older people are valued, treated fairly, and have their rights respected. And that has to include legal protection from discrimination, not just in employment, where we currently have it, but when older people are going about their day-to-day lives. HNI has been campaigning for age discrimination law in the provision of goods, facilities and services for a very long time, well over a decade. In our written submission to the committee, we set out a brief summary of the milestones to date, which hopefully has been useful, going back to the first programme for government commitment in 2011. And I can confidently say that this prolonged failure to deliver on that commitment is a cause of deep frustration and, I would say, hurt for the older people that we engage with. We have a consultative forum in HNI that we work closely with to ensure that older people's voices are at the heart of our work. We also support the community-based age sector, and we have delivered 3 lived experience surveys since 2020, and also through the day-to-day delivery of all of our services, we build relationships with thousands of older people and their families. So from all of that engagement, it's very clear to us that from older people there is a very strong call to have this legislation introduced. And we also see firsthand the impact on older people whenever they're not afforded the same level of protection as other equality groups. So when an individual believes they've been treated in a discriminatory way because of their age, there's no route to challenge that or to seek accountability or redress. The Equality Commission, at an event we hosted yesterday in the Lawn Gallery, cited the figure that they received 32 complaints in 2023-24 that would have fallen under the scope of GFS legislation, but sadly they had to tell those people that there was nothing they could do because it doesn't exist here. And that lack of protection not only impacts those individuals, but the wider consequence of that in the long term is that ageist attitudes and behaviour become normalised in society. It creates an environment where even many older people themselves don't see themselves as rights holders and come to expect unequal treatment. As society ages at a rapid pace, we can't continue to allow the normalisation of ageism and discrimination. So we need better protection that will not only benefit older people now, but will build the kind of world that we all want to grow older in. So I'm just going to highlight a couple of key points from our written submission that we think merit further discussion. With regards to the law in Great Britain, AGNI believes that as a minimum, older people in Northern Ireland should have the same protections as elsewhere in the UK, but we do have some concerns about the GB law. We've outlined those in our submission. It's particularly around the exemptions that exist. So Age UK, our colleagues in Age UK have provided evidence to the UK Women and Equalities Committee on this issue and highlighted that there's three areas where they think, three key things that they think the ongoing unjustified discrimination can be attributed to. The first is those individual and systemic barriers that someone might face if they want to bring a case. The second is the broad exemptions, particularly for the financial services industry. And then the third would be general age-based restrictions in healthcare provision. So we would share those concerns and we would like to see law brought in Northern Ireland that can do better for the people of Northern Ireland. Older people do understand that some exemptions are necessary. Differential treatment is not always discriminatory treatment. But the issues that are connected to this are leading older people to still be treated less favourably because of their age, and we need to address that. We've heard from older people who feel they're not taken seriously when accessing healthcare. We've seen startling information come through the COVID inquiry that older people have at times felt that their lives are less valuable than others, and that's something that really should be a source of shame for us as a society. In terms of the EU, we did highlight in our submission that long-term project within the EU to develop goods, facilities and services law, which has been going on since 2008. So just to reiterate that we really would stress that it's important older people don't lose out on any progress that does get made at that level. The current protections that we have with regards to employment and education did come from an EU directive, so naturally we would be concerned that any future progress when it comes to goods, facilities and services is not missed out on by people here. We've also set out in our submission the impact on older people that we can observe. We've referenced as much as we can find of the best available data and research, but there does need to be more research undertaken. I think most startling for us is from our own lived experience survey last year, in which 79% of respondents rated equal access to healthcare as an essential issue, and it brought that out as the top concern for older people across that whole piece of research. So we would like to see, for example, the Department for Health undertaking regular research with this regard as part of their equality duty to older people as a Section 75 group. And obviously also the financial sector. We get so many complaints and concerns raised through our advice line of people particularly dealing with insurance companies, where it's clear that there are still blanket policies being applied that allow people to treat someone different because of their age. Older people are falling through the cracks of what is admittedly a complex market, but it just continues to apply these blanket policies that leaves older people with fewer options and higher premiums. And I just want to draw attention finally to indirect discrimination, which again we outline in our submission, just to highlight that a lot of what we hear from older people, it wouldn't always be direct discrimination, it would be the structural barriers to accessing services that particularly impact on them because of their age. So where a service depends entirely on being online or having access to a smartphone, older people will be excluded from that, and our future law would need to address that as well. So in closing, we are really grateful and pleased to be here today to speak up for older people who feel very strongly that the ongoing failure to legislate for their equality and rights reflects very poorly on the extent to which the Northern Ireland Executive values them and their contribution to society. We hope that this committee's inquiry will provide the necessary spotlight on this issue to finally make some progress and close this urgent equality gap.
Thank you, Kelly. Would you like to?
Hopefully I won't be too repetitive, but I'm very much in support of what Kelly has just said. My name's Evelyn Hoy and I'm the Chief Executive for the Commissioner for Older People. Eddie Lynch, his term of office ended in June 2024, but he has stayed on in a caretaker capacity just for a period of up to 6 months whilst a new Commissioner will be appointed. And he's asked me to extend his apology for being unavailable today. You're aware that the most obvious gap in the equality legislation in Northern Ireland is goods, facilities and services on the basis of a person's age, and I commend your colleague Claire Sugden on her proposal to introduce the Members' Bill to plug that gap. Since 2014, the Commissioner has been advising the need for legislation to protect older people, but really all citizens, from discrimination on the basis of often arbitrary or spurious age limitations. There have been several false dawns as regards progress on this issue, including the 2015 consultation on proposals for age discrimination legislation and the commitment on age discrimination legislation in the New Decade, New Approach in 2020. So it's my fervent hope that your initiative proves successful. It remains contradictory to develop age discrimination legislation to protect older people and not also include younger people. No anti-discrimination legislation should exclude any particular group because of perceived complexity. When Cockney consulted with older people, many of them expressed that they would want to see the legislation extended to their children and grandchildren. The ageing society in Northern Ireland is largely being ignored by government here. Despite published advice from the Commissioner to the First and Deputy First Minister this year, the new draft programme for government was published less than a month ago without practically any reference to the major demographic changes of an ageing society. I sincerely hope that the committee will seek to hear from the Commissioner and others about the absence of older people and the challenge of an ageing society before the consultation period ends. He will of course be responding to that consultation and publishing his response. This year, the Commissioner also released a report entitled Are You Ageist? The Commissioner engaged widely with older people through a survey, some focus groups and specific events, seeking their views on the effect ageism has on their everyday lives. 49% of older people reported having experienced direct ageism, and within ageism, of course, there is the issue of discrimination. 60% agreed that older people were viewed as frail, vulnerable or dependent. 63% believed that modern workplaces do not cater to their needs. And 95% of older people surveyed agreed that older people have a lot to contribute to the workplace and society. From this, it's clear that older people experience ageism, which includes discrimination, widely in our society and in 3 distinct categories. There's institutional ageism, our laws, our rules, our practice and policies that are prejudiced, biased or discriminatory. There's interpersonal ageism, the disrespect and patronising language, behaviours and interactions with others. And sadly, self-directed ageism, internalising society bias, cultural tropes about ageing leading to self-limiting behaviours. Our comprehensive report on ageism in Northern Ireland, Are You Ageist?, is available on our website and every member of the committee and the Assembly should read it. So why do we care about ageism and discrimination that derives from it? Equality legislation is at heart a mechanism of fairness. As well as playing a direct role in tackling specific discriminatory offences, the legislation serves to reinforce the values of a cohesive society. Laws are an expression of our values as a society, and everyone in our society, young and old, is of value. As well as providing a range of protections at its sharpest point of litigation, the development of equality law on age discrimination will promote awareness of ageism across society in all its forms. It will require consideration of ageism by public authorities when devising policies, services and practice. It will encourage and, when required, force changes in practice, training and development for practitioners. It'll challenge the stereotypes and tropes that all too easily go unchallenged in public, political and media discourse. and it will prioritise the collection of some of the data about public services that Kelly mentioned, disaggregated by appropriate age categories so that we can see more clearly where we are succeeding in tackling discrimination and where we're not making impacts that we could be making. If we achieve all that, the legislation will have secured its intent to protect people from discrimination on the basis of their age. It's simply not acceptable to the Commissioner for Older People to hear from them themselves that they are treated unfairly, unequally and in a discriminatory way. It is especially disturbing to hear older people express ageist thoughts about themselves. Older people are net contributors to our society through taxes, employment, volunteerism, childcare and caring for each other. Instead of being characterised as a drain on our health and social care systems, they in fact provide thousands of hours of unpaid care. It's long past time that the Assembly recognised the value of older people and legislated to protect them from discrimination. Thank you.
Thank you very much. And it was a good event yesterday. I was only able to get there for a small part, but I have read your report. So in the AGNI's submission, it was a really good point that was made. It was around it. It's not just about disparities between Northern Ireland and the rest of the UK and the Republic of Ireland, but it's also the internal disparities, and I think that was a point really well made. So I had a quick Google there. Unfortunately, this is the one day that Claire Sugden's not here, but she's thinking about standalone age discrimination legislation, and a lot of the evidence that we have received to date has been really about, should we have our own single equality bill here and tidy it up and learn from issues like financial services and stuff? And so from your point of view, would you have a preference for a standalone age discrimination, or that if you think, or some sort of comprehensive overarching? Is there, as a sector, would you?
Well, I think from AGNI's point of view, we're not prescriptive about how this will be taken forward, but I think from our own knowledge and from our own experience, I think there is something more powerful in having legislation which would speak directly to older people in terms of this legislation is about you. Age is about age. It's really important, because one of the things that has been alluded to is the fact that older people don't always see themselves as rights holders, don't always see the everyday actions, assumptions, prejudices made about age as being about their rights or about being something that they can do anything about, because it is so everyday, it is so ingrained in the experiences that they have. So I think there is something very powerful in having age as the title of legislation, which is about recognising that gap in equality legislation, and also about promoting to older people and to others that age is a category in which people should not be discriminated against.
I think I agree with what Pascal is saying. I also think an Equality Act would be a very ambitious target for the Northern Ireland Assembly, but we've been talking about age discrimination legislation for 10 years and we still don't have it. I would settle for action.
Okay.
I was just going to note that whatever way it goes, the work will still have to be done to develop age discrimination law, because with those other pieces of law, it is, as you said, Chair, about tidying things up and pulling together, whereas we really still need to develop this from scratch almost. So whichever route the committee chooses to endorse, that's still going to require that somebody does that work.
Okay. Also in the AGNI submission, you talked about the public sector equality duty, and the phraseology there is around have due regard to. To what degree do you feel that public services and bodies actually do have due regard to? Is that something even that needs to be tidied up as well?
I think also we probably need much more up-to-date research in relation to that. Okay. Certainly we do know that from an older person's point of view, as Kelly said in our lived experience report and the conversations we have with older people, there's a very strong sense and perception that in fact they aren't being treated the same as other people. but do not know what to do with that information, apart from a level of, if you like, of frustration. And we know there's some evidence, particularly I suppose more up to date in terms of England, you know, in terms of older people having equal access to mental health therapies, talking therapies and so on, you know, in terms of the prescribing, what older people are prescribed, or even the assessment around depression. So in terms of that unequal access to support that might be available to others of a different age. There's evidence, if you like, around that. And if you look at screening services, for example, you know, often there's an age cut off in relation to that. So I think that there's already evidence that, in fact, there are elements of which do affect people, and they are based solely on age.
Okay, just go ahead.
No, do you want me to start?
No, I was going to ask one question for you, and then you can maybe bolt it on. It's just in terms of your submission there, you talked about Article 2, Section 1 of the Northern Ireland Protocol, and you said that there's no commitment to keep pace with the EU equality legislation related to some protected characteristics, including age. Yes. And you talked about amending the protocol and or the Good Friday Agreement. I'm just wondering how far those conversations have gone with the UK government, NIO, in terms of...
Yeah, well, I think in common with a lot of sort of alignment with EU law, very little of that conversation has really bottomed out as yet. I think that coming back to the equality duty of the Northern Ireland Act, if you don't mind, I think that there are quite stark examples where that simply isn't being paid due regard to. Okay. We see multiple consultations in a year coming out where the needs of older people haven't been considered or have been screened out at a very early opportunity. Mm-hmm. We're currently undertaking a judicial review on the continuing health care policy of health. We won it in the lower court, and one of the biggest criticisms of the court was that no regard had been paid to the equality impacts on older people. So, I mean, I would... You know, at this point, you would hope, and I think it was said at the COVID inquiry, that the equality duties are within the DNA of our policy community, you know, that it's part of our thinking around how we develop policy. But sadly, I don't think that, you know, bears evidence all the time. So there are multiple opportunities in a year where we are going back to policymakers and saying, what have you done about older people? Where is the evidence of what you've gathered about older people? How have you considered that in the services you're trying to deliver, the practice you're trying to, you know, bring forward? And that's why I think age goods facilities and services legislation, you know, the knowledge and understanding and awareness around all of those issues will increase as soon as we start talking about and developing a bill in that regard. And that would be very, very useful.
Okay, thank you. I'm going to move on. Deputy Chair, please.
Thank you everyone for coming in and for your presentations and submission to our inquiry as well. And something that I was interested in as I was listening to you is I'd be really interested to hear from your work and your research if you feel there are particular spaces or groups that are maybe at risk, especially of ageism. Does it interlink with any other protected characteristics such as disability or race or gender, for example? Is that something your work and research has shown?
I think I would say that, you know, older people are, there's about 450 older people under, you know, over the age of 60 in Northern Ireland, and they're as diverse as the rest of the population. There is no one older who doesn't have the same diversity of experience as a younger person. So they have all the multiple identities that you would imagine. They're living with disabilities, they're in minority ethnic communities, they're in lesbian gay relationships, they're right across all of the protected characteristics. Some have dependents, some do not, some are married, some are not. And you know, I think you can't treat older people just as a homogenous group. So they will be subject to discrimination for multiple characteristics, but the one that really frustrates them at the moment is that of the basis of age. And I'll give you an example. We had a case where a lady who had lived with sight impairment all her life reached 65, and she moved from disability services in a trust to older people's services. And in doing that, she lost some of the services that were provided to her because she was disabled, because those services weren't available in older people's services. Now, that's a silly administrative, you know, flaw in the system, but she had no recourse in the law to challenge that discrimination. she relied on us to come and advocate on her behalf. And so you really, it's when you come across silly things like that you really realise those things probably would be dealt with at the practice development, the policy development end, if age discrimination legislation existed.
I would just want to mention in terms of, we raised intersectionality quite a lot in our budget consultation responses that were done in recent months. And while it's not a Section 75 equality group, I think sort of social inequality and wealth inequality would be a key intersecting one where we'd see some older people who are more at risk of being treated unfairly. And I know the Equality Act in GB is looking at ways to bring that into the scope of their protections for people. But certainly in recent weeks with the news around the winter fuel payment, it has put older people and poverty very much back in the spotlight. So there's going to be groups there that we would be very concerned about.
I suppose just a point around, I suppose it's inequality and the cumulative disadvantage over time. So say if you have someone that belongs within a particular marginalised group, as they get older, the disadvantages that they've experienced early on in life will become more impactful as they age. So health issues and things like that. So in terms of addressing wider inequality, it's why age would be particularly important. And then I suppose when you're talking about that intersectionality as well, it can manifest in a lot of different ways. So for example, in the likes of domestic abuse, older women will be more at risk and they'll be more reliant on their partner due to financial reasons and things like that. But equally, there's research suggesting that older men, because of their increased vulnerability, are more likely than younger men to experience domestic abuse. So there's a lot of different sort of ways that it manifests across the lifespan for different characteristics.
If I have time for supplementary, thank you. That's really insightful and something that I'd really be keen as well if you to discuss more. Kelly, if it's okay. I think you'd mentioned there are exemptions in the laws in GB that you don't want to see replicated here. Could you maybe talk about more to those? Give us a few examples if that's helpful.
Well, the two big ones that have caused issues would be the financial services sector, and I think the problem there is very much that it's you're trying to apply an area of equality law across a kind of market-driven sector that it doesn't naturally the aims of both don't necessarily meet. So the type of exemptions that are applied in GB have led to a situation where what we would hear from our Age UK colleagues anecdotally almost is that essentially people, the prohibition really only disallows refusing to sell a product, but anything after that is kind of fair game, so the setting of premiums and all of that kind of practice that goes on in that sector on a blanket policy relating to, well, once you're over this age, that's it, you pay so much extra.
Sorry, do you mean then, so if somebody applies for a mortgage, for example, at 61 or something, is that what you're talking about? Some sort of
or travel insurance or driver's insurance, those kind of things. So quite often it's an age, it's that kind of as well. Is that the kind of thing as well as financial products?
Okay. Sorry.
No, that's fine.
So that would be the main issue really with those type of services, and that what that does then is excludes older people from being able to have the best options, the cheapest options. So it causes a knock-on effect and increased financial burdens then. And then the other big issue would be with healthcare, where again there's difficulties with how the equality law is applied whenever you've got public service providers whose budgets are very stretched, and who are then, even within the law, they're finding ways to be able to justify maybe ruling older people out from treatment. There's evidence there of things like cancer treatments, older people not getting equal access. A big one would be talking therapies for mental health concerns, where we see a huge drop off in the statistics of people who get offered counselling as opposed to medication. When it comes to access to mental health services, as you get older, it just drops off dramatically. And that's something obviously we're dealing with here as well, even in terms of Section 75 and the healthcare budget that's been proposed and was consulted on recently, where you can see that 11 of the cost-cutting proposals are there, and 10 of them disproportionately impact older people. The analysis that the department has done accepts that, but there's nothing being presented in terms of mitigations. So it's just this kind of acceptance that, well, when you've got a tight budget, equality suffers.
Thank you. I think it's important to understand also that, there's what public authorities can do, and then there's what other marketplaces can do, and it's not just financial instruments. So, for example, we've seen cases now in a very competitive private rental market. There's over 17,000 people in Northern Ireland over the age of 60 in private rental accommodation, and there's a very competitive market out there for every property that comes up. So if you're an older person who's needing maybe aids and adaptations to your dwelling, you're a further complication for a landlord. You're not as suitable a candidate for some of the homes that you maybe could be offered. And at the same time, even if you could afford it, you couldn't get a mortgage to buy a property. There's been a lot of work done recently on over 50s co-ownership mechanisms, but even that has limitations, so if you haven't bought your house early, if you haven't lived in the kind of property ladder, that's a very risky place to end up being, where you can be discriminated against quite insidiously, as you get older.
Okay, Harry, please.
Thank you very much, Chair. And first of all, good event yesterday. It all seemed to go very well for you. First of all, I was just wondering, so what age does one become an older person nowadays? How is that defined?
Well, sorry, go ahead. You don't mind me answering that one. The Commissioner's legislation says that you have to be over 60. Okay. But as we all get a bit closer to 60, we're all a bit dubious about that particular age limit. But yeah, 60. I mean, older people it's one of the reasons there isn't a UN charter on the rights of older people. Nobody can decide what older means, So yeah, I mean, it's very much a mindset thing, isn't it?
Yeah. Well, just as a light comment, yes. I certainly remember a colleague of mine saying that an older person is always 10 years older than me.
That's exactly right. Yeah. And okay, Chair.
Yes,
we'll mention protection and stuff. And you talked about the different laws and stuff, so that's been well covered. One thing got me was seeking treatment. There was a comment not encouraged. Like here, 79% of people, which was very concerning. So who wouldn't be encouraging?
Well, I think the experience that came through in our lived experience survey was around older people, and it wasn't just one, it was quite a number of people who said, when I go to the doctor, I feel as if I'm not important. I feel as if I'm not heard, I'm not listened. And some of that, I think, ties into that view of, well, you're this age. It's an ageism or perception. What would you expect, if you like, at this age? So, and let's say that it came from more than one person who said, and in fact, I don't feel that I'm encouraged to take anything forward. So it was health professionals not taking me seriously in terms of the concerns that I have about my health. And taking that forward. I think the other thing that came through strongly from our lived experience survey was older people saying, people used condescending language, if you like, when they're talking to me. They perhaps don't give me time. Well, I have to make a decision and then make an assumption that I can't make a decision. So I think it comes through how older people feel they are being treated whenever they go, that they feel they're being a nuisance, that they feel that in fact that they're not being given the same time or attention as others.
Yeah, if I could add into that, I'll give you the example of the recent changes to GP services. After COVID, we were faced with massive changes to our GP services, where everyone had to start making telephone appointments. And sometimes it takes 140 or 150 calls in the morning to get through to your GP. After that, you might get a call back. You may never get a face-to-face conversation. That's a policy that has been implemented across all GPs, and there's not a single equality impact assessment associated to it. Not one. There isn't any challenge to it because it's not, I mean, everyone can see the obvious discriminatory action there, but we don't have any goods, facilities and services legislation to challenge it through. And, that's something that impacts you no matter how old you are. So, say you're a younger carer of an older person, that's something that impacts you. If you're a younger person, if you have young children in your home, same thing. But the inequality impact assessment has never been actually done. And we saw, very sadly, some very poor practice during COVID. Our lack of planning for the COVID pandemic meant that decisions had to be taken much more quickly, and without any opportunity to consider impacts on, for example, older people coming from care homes who were refused hospital treatment or refused even admission to hospital. So there's lots of examples of that.
Thank you. And digital exclusion, do you feel that's a lack of training? It's certainly not a lack of ability, but as you say, sometimes maybe a wee bit more time's needed, and that's grand. But
I think for some people, yes, it's about confidence. It's about training and support, and those things are all really important to make sure that they are in place. But I know I think the research would evidence, in some sense, is that technology is developing at such a pace. In some senses, you could never keep catching up with how technology is changing. So I think that's one element. Excuse me. And I think the other element around technology is the fact that, particularly for people, say, who have a cognitive impairment such as dementia or other kind of visual impairments and so on and so forth, that is not only just a case of training or making sure you have the right device. It's actually, for many people, not accessible.
Mm-hmm. Mm-hmm. And if I could add to that as well, there's two sort of things I would say about technology. One is that the current population, perhaps without wanting to be ageist or discriminatory in any way, of maybe 70 plus, didn't come up through their lives with smartphones in their hands. But the next generation did. And so it's potentially quite ageist to think that older people are excluded digitally, because a huge number of them are, supporting childcare for their grandchildren. They're banking online. They're being provided all of their government activity. They're booking their MOTs. They're, doing everything that we all do. Not everybody's happy about it, but that's fair enough. But I think where technology is really going to be very interesting is in the next 10 years around assistive technology for older people as a proxy for care. So, for example, telemedicine, where you're having your GP consultation through your television, or we're using assistive technology to track movements of people, so that we're monitoring falls, or my biggest issue around that would be that it can never be a proxy for a human interaction. It's very assistive, it's very helpful. I'd imagine that we will adopt a lot of it because it will be cheaper and will be more available than a workforce, but it can never really be a replacement for human interaction.
Okay, thank you very much, and I do hope you get a replacement for Eddie soon. I know he's been around a long time. I think he was not job from 2016.
Yeah,
right?
he did 2 full terms.
And I know it'd be hard to
of 4
replace,
years.
but all the best. Thank you, Chair.
Timothy, please.
Thanks very much, Chair. I suppose want to start off by picking up again a number of members have regarding the lived experience survey in 2023. Where we've heard some people that took part in that felt sidelined, forgotten about, dismissed and no longer important to the health service. Some said they felt they were not encouraged to seek treatment and that the pain they experienced was not treated seriously. On the back of that, I know it's relatively new. Have you had any correspondence with the Department of Health to bring the findings to them? Have you engaged with the Health Minister? Have you been asked to go to the committee, the Health Committee? Because certainly that's very strong, what's come across there. It's very concerning, and I'd be interested to know, so once you've got this raw data of how people feel, it seems to me it's a culture that is potentially existing or perceived to exist. What yous have done about that to try and change it?
Well, I suppose in terms of our responses to consultations, obviously the voice of older people is the element, if you like, that we would include within that. We have spent the time, I suppose, sharing the findings with different groups and networks. We haven't approached the committee yet, but I think that's a really good idea, and we're going to actually take that forward. Kelly, do you want to add anything?
We also, at our last all-party group meeting, before the summer recess. The topic of discussion was access to primary care and GP services, and so while that meeting was dealing with some of the issues that Evan raised around telephone first as a policy and how it impacts older people, we had a really robust discussion as well there about how older people feel treated when they do get in the room with the GP or when they're with those primary care providers. And the chair of the Royal College of GPs was part of that discussion as well, and she did say that she was going to take a lot of that feedback back to her organisation as well. I think there does need to be a focus when it comes to training all across all healthcare professionals. And there's some great training that's going on out there, and AGNI would be a part of a lot of that. We would work very closely with the PHA as well. So it's not just what we put in the report; it's what we do in our ongoing work with those health organisations, statutory providers. And our consultative forum plays a really key role. So we would have that consultative forum. They would go out and meet with stakeholders, meet with the PHA, help the PHA design training materials. Help the different trusts as well with their own messaging. We've worked on things like if a trust has a leaflet or a poster that needs to go up that's particularly geared at older people, our consultative forum would sit down and go through the content. So we have that ongoing relationship, with a lot of those statutory providers. But I think you're right. A good sort of sit down with the committees, and that would be useful.
On page 47 of your evidence, you've laid out and you've given it orally as well. Where it appears that older people have been failed by the executive. The pledge to extend age discrimination legislation in 2011-2015 programme for government didn't materialise. There's been a failure to renew the active age strategy, which expired in 2022. No commitment to legislating age discrimination in the draft programme for government 2016. New decade, new approach, again promised legislation and nothing has come forward. No commitment to anything in the current programme for government. Do you believe that devolution, or I suppose specifically looking at it, that the Executive Office is delivering for pensioners?
Well, I think that for older people themselves feel very disappointed, frustrated, and some will feel very angry at in fact about the slow pace, if you like, of the introduction of this legislation. But I think that they are still hopeful that, and certainly the action of this committee, I think, is really important in terms of looking at this, the gaps in inequality legislation, and so they're hopeful that change is going to come.
Can I add to that? I mean, I think I said very bluntly in my opening statement that government is not alert to the needs of older people in Northern Ireland. But beyond that, we are walking blindfolded into the biggest demographic change for society ever. The pace and the size of the change that's happening is remarkable. And we put that to the First and Deputy First Minister in a published document with firm recommendations on the programme for government, and yet it was published without any reference at the highest level to older people. And when we've, dived underneath that to see if they're in pockets elsewhere, it's very, very hard to find any mention of older people. And that sits very contrary, I think, to a desire that we all have to kind of get there. Nobody wants to not be an older person at some point in their lives, and you'd be amazed how quickly it comes upon you. So it just seems to me that it's such an obvious omission. But the demographic change is going to be so difficult for us if we don't plan well for it. We're going to lose a huge amount of our tax base. We're going to lose unless people work longer. And so we have to improve employment rights for older people. We have to start retaining older people in the workforce and retaining them as economically productive people in the workforce. Otherwise, it's going to be very, very difficult to manage the scale of older people in our society in relative terms to the younger people in our society.
One final point. For AGNI, if an elderly person in a care home insisted that they are given a bed bath by someone of the same biological sex, would that be viewed as transphobic by AGNI?
I think we can't comment on an individual case, if you like, without knowing what the circumstances are. So I don't think we would be in a position to comment on that.
Can I just ask, Kelly, as head of policy for AGNI, is your Twitter account in conflict with AGNI?
And my personal social media has absolutely nothing to do with my professional role.
Even though it's listed as who you're head of policy for AGNI?
I just find it doesn't say that on my personal Twitter. I find this line of questioning quite inappropriate.
So do I.
I'll let you reflect
He's
on what you
consistent.
have on your Twitter account, and I find it doesn't comply with what AGNI are trying to do.
That's ridiculous. Seriously, it's ridiculous.
Stupid here. Are you content for us to move on then?
Very much.
Apologies if there was any offence taken or not. Okay, so Brian, please, thank you.
Oh, Chair.
Yes, thank you.
Look, well, thank you for your attendance today, and you rightly highlight the huge contribution that older people make to society at every level, and particularly within family networks. And I'm sure many people would reflect, when that older generation goes, so much of the cohesion within families can decline, and the older generation keeps families together very much, and are hugely important. When you're commenting on different types of ageism, I think there'll always be a certain humour around age. I think of the birthday cards I usually get from my children, and so there will always be that element. But I suppose it's being wary about in our own minds to think where that could become an attitude, or as you're highlighting here, a deprioritisation of the needs of older people. And thank you for your paper focusing on the lack of age discrimination legislation on the provision of goods, facilities and services. So as you've already commented, one of the relevant areas is in health provision, health service provision. I'm wondering whether you could give just some more examples where you feel that is particularly acute. In fairness, thinking of some elderly relatives within my own family network, I mean, they have received good care, and I'm sure others would recognise it, but whether you can highlight where you feel in health service provision there has been a different attitude towards older people. And on a related topic, and I don't dismiss all of the difficult circumstances around this topic, but for those who are promoting assisted dying or euthanasia, would you have concerns, again, how that would affect people's attitude towards health service provision, that the health service should always be pro-life, and as a member of a party that is pro-life, that the focus should always be on helping people to be well and to live longer and live quality life. And I would have concern in that debate that it's promoting a different attitude, and the danger of implying to some people that they're almost being a burden on society.
It's quite a complex issue, as you
Yes.
can imagine. I think the issue of feeling like a burden has come across very much in our ageism work, and we've seen it time and again. People give us that sense of, I feel like I'm a burden to my family, I feel like I'm a burden to, the health service and others. And this is a bit about what we talk about, that kind of self-ageist attitude. But I think what's really driving that, if I may say, is a lot of the discourse that comes to older people from the rest of society. So, for example, the BBC wrote an article this week about Programme for Government, and in it they mentioned that older people weren't present in it. And their very last line in the article about the Programme for Government was that older people, take up so much of the health and social care budget. Well, of course they do. That's when you need health and social care.
They've paid into it all their lives.
But it was such a negative way to end the article, and they're just this throwaway line about it's all about older people blocking beds and clogging up waiting lists and it's nonsense. It's absolute nonsense, and it's not how anybody in this room would want to be treated when they're that age. So I don't understand why we persist with it. I agree with you about humour. Older people are brilliant crack, and when you're in a room with them, you laugh your head off. They are fantastic, some of them, and some of them are not, because we're all very much the same. But that's not the kind of language that they're objecting to. They're objecting to their GP saying to them, well, of course you're sore, you're 80, you know, or well, you can't climb the stairs. Well, like, who can at 80? But if you were a younger person going in and saying, well, I have very sore knees and I'm unable to climb the stairs, well, I'll get you some physiotherapy and I'll get you a pain-killing injection, and I'll get you. So it's sort of this pervasive, oh, well, it's your age, you can expect it. You know, that's what happens when we get old. Nonsense. You know, there are plenty of 85-year-olds out there walking their dogs day in, day out, and would run rings around most of us. So it's more that sort of message that comes constantly at you when you're an older person. It's how people speak to you in shops, it's how people speak to you on buses, you know, it's all kinds of things like that. I'm not going to really tackle the assisted dying issue except to say that we are there to safeguard the interests of older people, and we would do nothing about older people without older people. And I think this is an issue where there will be no consensus on assisted dying. It will be so personal to people and their faith and their culture and how they have lived in their lives and their experience of profound illness and all of those things. So I think we'll always be representing the plurality of that view rather than, you know, the Commissioner having a view on assisted dying.
Thank you. Sinead, please.
Thanks, Chair. I suppose, Evelyn, you'd mentioned it, like the demographic change, it's going to come at us really, really quickly.
Yeah.
It's, you know, I can see it in my constituency, and just how very ill-equipped our public services are, because we've kind of depleted them for many, many years now. And so they can't handle it. And just back to one of the questions that Connie asked you earlier on about ageism and its impact in certain groups within the society. I'm really concerned about older women, because a lot of them have been maybe working from in the home. They're dependent maybe on their spouse or their partner's pension. And then some of them don't have, you know, maybe an added pension. So we are having an awful lot of older women that are living out their latter years in real poverty. And we've seen there the other day talking about the winter fuel payment and the cut, and the discussions that were happening around that, and the Labour government saying, you know, those that most need it are going to get it, you know, because if you've got pension credit, you'll get it. But there's 40% of people that are entitled to pension credits, and they don't know that they are, because there's this lack of, and I don't mean this in a critical way, but, you know, that advocacy and their ability to kind of stand up, speak up, and get the support. It's the attention for support is not in their space. And so we have a lot of people going to be living out their end years in poverty, and I'm really concerned within the overall ageism issues. A greater proportion of women are going to be really badly affected, and I'm not sure as society, I know, and right through from childcare right through the whole of society, we still don't have the data. We don't have the data that we can drill down and see who are we talking about, and what do they need, and what additional support that women in those circumstances that have cared for children, have come out of their careers, have had depleted wages as a result of that, have spent many years in the home and now have no pension as a result of it, and living out their end years in poverty. And how are we dealing within age discrimination? We need a way of dealing with the discrimination within that as well.
Absolutely.
So,
Yeah,
sorry, that's...
Go ahead, Kelly. That one, just to say that, I mean, I think you're really spot on about the data, because in a lot of our policy work, we would quote a figure that comes from UK research around the fact that the highest risk group for poverty in later life would be single women. So we know that from the UK-wide data, but we can't extrapolate what that means in Northern Ireland unless somebody does that research here. And just to note as well that we have raised the fact that in our response to the winter fuel payment decision, We know it wasn't equality screened by the UK government, or if it was, they're not releasing that. I have been working with some contacts on the Communities Committee actually to find out if the Department for Communities intend to equality impact assess that decision if it's going to be implemented here, and have heard back that the department does intend to put a screening together. But what we'll be looking for in that will be not just the disproportionate impact on older people as a group, but on women, on older women in particular, because the people that fall in that bracket where they just have enough income to take them over the pension credit threshold, which is very low at 218 pounds, but are still at risk of financial hardship. As you've rightly pointed out, Sinead, they are not primarily, but they are disproportionately women because of all those issues with lower pensions, and that there is a gender pension gap as much as there's a gender pay gap.
Sorry, if I could just say about data in particular, we've been very shocked over the years at how difficult it is to disaggregate data by age range, and in fact one of the big cuts, we were looking recently at GB and how they are providing a kind of a dashboard for older people's data on a regular basis, so that anyone, any researcher, any person who's interested can go and look at what the data is around older people across a range of issues. We've asked for that from NISRA here, and we've been told that that's one of the cuts that they're making this year, that they won't be able to provide that. Now, I think that is in itself a very discriminatory approach to take, and I think also it's very important to consider who you mean by older people, because it's all right knowing about everybody over 60, but that tells you nothing about everybody between 80 and 90. There are over 13,000 people in Northern Ireland who are over 90. We don't know anything about them. So, it's really, I think the point on data is extremely well made.
And I think the other point in terms of both data and also poverty, as Kelly said, we know if you're single, you're more and a pension, you're more likely to be poor, and also the older person is more likely to be poor. So there is something about linking poverty, if you like, and looking at age as well. The other element I think that raises when you discuss that is just the importance of advice, information and advice around what am I entitled to for older people, because often older people say that's not for me, I'll not get anything there. So that lack of knowledge, that lack of understanding, and also getting the support to be able to go through, whether it's a benefit form, whether it's anything. That's why we have an advice service which is about checking benefit entitlement. But we know that sometimes older people are reluctant to share some of their financial information because they are reluctant to say, well, who will see this? What will you do with this? What are the implications for me? As well as the long forms and the long processes that people have to go through. So there's a number of other barriers, if you like, in place for people to actually get the extra help that they are entitled to.
They make the call.
Sorry, we need to move on. Do I have another question?
No, I'll just leave it at that because I'm not aware
Carol,
that there's
please.
other questions here.
Thank you. So, in terms of programme for government, the consultation's out, and I'm sure you sort of out and knock your socks off. Yes. Response in. I'm counting on it. I do think that there are a lot of sectors that aren't mentioned. It doesn't mean to say they're not there, but it does need to be, the end result needs to show things that need to be done. Paula and I mean, you probably remember, Paula, when we were on the Health Committee and we were looking at budgets, when we asked for a breakdown of the equality screening and the impact assessment, the department openly admitted it had broken 5 out of 11. So it was age, disability, women, LGBT, children. And for me, that's going to happen now. It means I've already mentioned it in terms of winter fuel. I don't know if communities, the department's going to do a screening exercise, probably will. But at the minute, we have a lot of people, particularly women, who have grown up in poverty, and they're going to hopefully grow older. And again, they're going to be even poorer. So in terms of this committee, what we're looking at are gaps in equality. So, you have mentioned goods and facilities and services. So that could be something that we need to do. But in terms of screening and equality impacts, that's one of the biggest gaps there are.
It is.
So it's
Absolutely
massive.
is.
So if, just from what you said lastly about NISRA,
Yes.
if that was a recommendation, I would particularly welcome it from yourselves, because how do we know? I don't mind filling out, are you 35 to 55, are you 55? You know, because I understand that, but I would encourage us to really put that in.
Yeah, we wrote a letter, didn't we?
We did. We've already written to NISRA, and we've written to the First and Deputy First Minister about it
Even
as well.
to this
But
committee.
certainly we'll write
Yeah.
to the committee as well. The issue is not the data collection, it's the provision of the analysis. You know, I'd say there's probably tons and tons of information right across all of government on older people, their provision of services, the practice that goes on. And I have to say, if I may, that we see excellent practice across the health service, across, you know, social care all the time. You know, I don't want people
Right,
to come
yeah.
across as if it's all broken and there's no chance, you know, but where it's not the norm, it can be brutal. It can be a brutal experience. But I think that there, you know, we just need to be a bit more creative around that. Now, the programme for government will set the tone for what data we collect. That's why, you see, I'm very resistant to older people being called a sector. They're not. They're 460,000 citizens.
Yeah.
They're not a sector. And that's why I think the issue of an ageing society is far more important in the programme for government, because it's going to impact on everybody. It's not just older people it will impact on. So I really do accept your point about the data.
And the other aspect of data for us is, you know, even in terms of preparing future-proofing services for us all.
Yes.
So there are huge issues in terms of adoptions for homes, around mobility issues, including children, young people and older people. There are massive issues in terms of disability. And the ageing community within that, it's going to be horrific. It's the, you know, it's so for us. And then my bugbear is that often good relations is got primacy above equality. So that in itself would need to, good relations needs to be defined in law to make sure that people aren't using it, not to provide services on an equal basis. So in terms of all that, the discrimination on the multiple characteristics, what you know, if you were sitting in this committee, what do you think we should be saying in terms of all these massive gaps? Is it the legislation, the data, the age discrimination, the single equality bill? I mean, all these things were blocked, you know, they were blocked.
Yeah.
So
I think for us it would be the age GFS legislation first
Okay.
and foremost. I think that you've got to put that in because a lot of the other stuff will be derived from it. The gathering of data, the policymakers' approach to new policies in relation to protecting people from discrimination on the basis of their age. But I also think it's the programme for government.
Okay.
I don't think you can go past that.
Thank you.
Okay, is that you?
Thank you, Karen.
Emma, you've been very patient. Are you still there?
Your hand up.
I know.
Yeah.
Go ahead, Emma. Thank you.
Brilliant. Thank you. So my feed's been cutting in and out, so if I break up, I'll turn my camera off again. Thanks very much for the presentation and the written briefing that you provided. I suppose I had a question around a note in the briefing. You referred to different instances of people having care that was sort of mismatched, and there was a particular reference to inappropriate care in nursing home facilities. And one of the biggest constituency issues that I deal with, obviously in a rural setting, is around care packages and provision of domiciliary care. And I suppose it sort of links into all of that we're talking around there, around an ageing population and maybe, you know, societal changes in terms of family size. And I suppose I wanted to ask you what your thoughts were in terms of that access and healthcare in the home for older people. And as we move away from bigger families, where it's one of my frustrations all the time that you could have families contact you that there could be 6 or 8 or 9 siblings and they're expected to take on the role of unpaid care for a family member, that puts an awful lot of pressure on the families, and then you see these relationship breakdowns and people under an awful lot of stress when the person is entitled to help, but it's just not available. I wondered if I could get your thoughts on that, and whether or not we're meeting people's needs there.
Yeah, I think we're definitely not, Emma, meeting people's needs there. We've released 2 reports on social care, and we've been involved with a lot of the conversation around social care reform. And domiciliary care was something that was very strange during COVID because it kind of dropped off the radar a bit. What happened was people who normally work for a living went on furlough, and so they were much more available to their older relatives during that time. But when they then went back to work, what should have been there as domiciliary care services no longer really existed, and it was a very difficult gap to fill. Now, the issue also for me is that nobody starts needing domiciliary care at the point where they're asking for it. It's usually been a few years of the family, all the siblings, the older spouse, the younger spouse, taking care of someone in their own home for a long time, until that becomes just so stressful and so difficult. And very, very many older people will tell us that they do not want to go into a residential home. So there's that issue as well. But no, I think, I would even say that the health department is very clear now about its inability to meet those service needs, and it's inevitably then creating blockages in all parts of the system, in health waiting lists, in hospitals, and in terms of people coming out of hospital and not being able to have a bit of help to just rehabilitate, to a much less dependent lifestyle. So, bring on social care reform. Couldn't happen fast enough,
Yeah, and just to echo some of that, in terms of our advice service, after benefit entitlements and financial arrangements around care is our second highest level of inquiries that Age&I actually receives. So first of all, it's a very complicated process. How do you go about it? Who do you ask? How do I know what I'm entitled to? And I think the other issue is quite often it happens at a time of crisis. So that I'm brought into this system, this complicated system, at a time when I'm probably feeling not great. My family around me are very worried. And often the older person themselves isn't really at the heart of the decision. It's about what can family do, how can we move people, because what older people tell us, they feel the pressure. They don't want to stay in hospital any longer than they need to. Often it's not, from a health point of view, it's not a good place to be either in terms of muscle wastage, in terms of deconditioning. So you do want older people to be out of hospital as quickly as possible, but the right support needs to be in the home so that they can do that, because that's where most people want to go in terms of that. But it's also important in terms of before, it shouldn't be about a crisis. I think Evelyn had talked about, in fact, people having to wait. It should be about helping me to live, actually, the independent life that I want to live, to stay well, to be out and about, to do the things that I want to do, and not have to wait for a crisis situation, if you like, to arise. So I think, unfortunately, it's an effect of our social care system, the lack of investment in our social care system, and the lack of priority for social care support.
Sorry. No. We're getting a wee bit off topic a little bit. Yes. The Assembly, we're going to have one of the motions coming up in a couple of weeks is around social care reform. So if you just want to do submissions to the political parties, they'll pick up on that. Emma, have you a follow-up question?
Chair, thanks very much for that. I suppose it was just, I'm sorry I've had to turn my camera off because they were breaking up there, but it sort of links in with, I suppose, the intersectionality of this through the responses that you gave to Connie's question. I suppose I've got that specific interest in it because I see this being an issue that really impacts on rural dwellers disproportionately. And again, going off topic, but it's obviously as a result of the fact that, we're not paying workers appropriately, and therefore we can't recruit, and that causes that problem. But no, I appreciate the report and the research, and obviously commit to doing whatever we can to support you there. Thank you.
Thank you, Emma. Okay, well, thank you very much. I am going to give the last word to you, Kelly, because that was quite a personalised line of questioning, and I just wondered, is there anything you'd like to say in response? I've had a couple of minutes to reflect.
No.
You okay?
Fine, yeah.
Well, thank you very much.
Quite unusual.
Thank you very much, and thank you to you all. Go ahead, quickly.
Just before the panel leaves, I would just like to say that I did think the comment by a member of the committee was very inappropriate. I'm not interested in what it related to. I don't think it's not something relating to our agenda. And I want to apologise that it happened at a committee that I'm a member. I think the member responsible should apologise, and I hope he will take that action. When people come to present evidence, it's not relating to their personal lives in any way. It's in their professional capacity, and so I wouldn't want the panel to leave without that being said.
If I could make a
yes,
comment.
please go ahead. Thank you.
Certainly, from what I said earlier on, I don't believe I have any need to withdraw from looking down through the Twitter account.
Okay, I'm going to draw a line. Thank you very much. Thank you very much.
This is not relevant.
Thank you very much. Thank you. Thank you very much.
It's about knowing appropriate behaviour as an elected representative.
Okay.
No, it's not.
Thank you. And we will be in touch. We may come back when we've got our recommendations in draft form. Thank you. Okay, members, we're going to move on. And just to... our next item there is around future steps around the equality legislation inquiry, and there is a pack, Claire's brief at page 59, and there was a submission in the table pack from the the Human Rights Consortium. I actually hadn't received the table pack, so I'll need to get a look at that. What are people's thoughts? Obviously that was age today. We also then need to speak to children and young people. Are there any other sections that we really want to drill down into? I think that was really good just to get a focus on older disability. Yes, okay.
Disability, and in terms of gaps in equality, I mean, to be honest with you, I think we need to bring the LGBTQ plus.
Yep.
But I mean, God knows what Timothy Goslin's going to say to him. So, but I think I need to be here because they're a group that have been discriminated against. So definitely age, disability, and then we've already had the women's sector up in terms of violence against women and girls. But in terms of gaps and equality and certain, I think if we just look at the Section 75 groups and see who we've missed.
Can I just confirm, we'd said we had invited some youth representation today, and they're coming in another date?
Yes, it was just short notice because we obviously thought the second panel was going to be about Paul Sweeney talking about the contributions. So that's
no
why
problem. I think that would be good as well. But other groups as well, I agree totally with Carol's recommendations too.
Go ahead, Timothy, and then Harry.
Just on that, do we need to bring in the housing executive? We talked about the police were coming in regarding what accusations were made last week about the institutional racism. I've been contacted by a number of people within the housing executive who have been appalled by that, so I think the opportunity should be given to them to come in and give their side of the story. I had mentioned last week the Ulster Human Rights Watch, South East Fermanagh Foundation, so it's a broad brush in the forward plan of what organisations will bring in, and I would like them certainly to be included. A note within the forward plan, there's no mention of bringing back Sir Declan Morgan, and we had talked at the end of the meeting last week that
usually it only goes in the forward work programme whenever it's pinned down, but you'll see in the table pack that there was a request from the CIJ and Amnesty to come off the back of the court ruling last week. So I think that we do need to have another panel looking at victims and survivors issues, and your proposal last week that we would invite some of the groups, and Carol had said, maybe look at panels. So we haven't forgotten about your suggestions last week. It's just the forward work programme only takes us as far as the clerk and his team have actually been able to pencil them in and get them. So we haven't.
confirmed. As long as they're getting the invitation, I'm happy enough.
Harry, please.
Just maybe another group we could consider would be some religious groups, maybe, Chair, that would feel themselves a minority.
Okay, no problem. Yep, go ahead, Brian.
And just to agree regarding the housing executive, I mean, when witnesses do come in, I mean, we are allowed to probe, what they tell us and to challenge, so and I think we also have to follow up if groups or any agency is been portrayed in a certain way. I think we're obliged to hear from them. But I know we have the police coming in. I think likewise the housing executive we should have in.
I think mayors were mentioned as well.
Yeah. Yeah,
and was the other group, was it racial support or migrant support?
There's 4 of them in total, but I can only...
They have been invited, but they weren't able to send somebody last week.
Okay.
They declined, actually, officially declined. But as you are picking up, Timothy, these threads, we keep coming back to them every few months, so we don't just have a session on something and not come back to it. So next week is the First Minister and Deputy First Minister coming, and then we have the TO officials to come and tell us what's happening with the racial equality strategy, refugee integration, and the revised race relations order. And then we have the PSNI coming, and then the forward work programmes there. So once we find out from the TO officials where they are in terms of the new strategy, then we can start looking at the elements within that. Okay, members, so where are we at then? So yes, we've got a few potential there. Forward work programme, yes. Just to remind members that we've got our trip to Ebrington on the 16th of October, which kept getting rescheduled, and I know it's a long way to Derry, but I do think that it's a really important session, so we can make sure that we keep that date as free as possible. We may look at changing the actual start time, but we will be pushing ahead with that date. And another really important issue is the Inter-Parliamentary Forum. They're coming to Northern Ireland, the Assembly, on the 15th of November. I went to London with Matthew O'Toole earlier in the year, and that's a really important forum, so we will let you know about any events relating to their visit. And then we are seeking agreement to schedule a briefing from the EU Affairs Manager on the 13th of November. Are people in agreement with that? Yep. And then what else have we got there? Just to write.
We were asked by the Independent Monitoring Authority for Citizens' Rights Agreements to brief the committee. They're a UK-wide one that looks at citizens' rights post-Brexit.
Okay.
As in the EU citizens' rights, and it might be an idea to slot them in on 13th of November as well.
Okay. And the next one then is to write to the First Minister and Deputy First Minister to seek ministerial attendance on that date. That must be to the Inter-Parliamentary Forum, is it? Okay. Are people happy with that? Mm-hmm. Okay, so there's quite a bit in the correspondence this week again, including the statutory rule on period products for public authorities and the fair employment regulations for school teachers. So just to advise that the committee will consider the statutory rules once the examiner of statutory rules has reported on them. I think that's really all I want to raise at this. Sorry, yes, that committee on the administration of justice and Amnesty International UK, if we can get them scheduled in for a session as well. Anything anybody else wants to raise?
Just that was a useful meeting, Chair.
Yep, that's very good. Okay. Any other business then? Just to remind members that the Northern Ireland Judicial Appointments Commission has requested to run a lunchtime event to provide information on its work and relevant issues to this committee and the Justice Committee. So are we fine to sponsor this event in February?
Yeah, sure.
Okay. Okay, members, that's it for today. Next meeting is next week. Thank you. Thanks, Paul.
Committee Room 30, Sound.